Welcome back, everybody. Why don't we get started? Welcome back. My name is Joe Landau, and I'm a professor here at Fordham, and this is our third and final panel. It's called Gaining and Losing Citizenship in the National Security Context. The panel builds, I think, on a lot of the questions that were raised in the morning panels. Questions like, what does citizenship mean? How do we understand in the national security context the distinction between the rights of citizens and foreign nationals, both on and off U.S. soil? How have our responses to these problems and these questions changed or stayed the same throughout history? And how can the immigration context shed light on the treatment of these questions in the national security context and vice versa? Now we move to additional questions this afternoon as we address issues of citizenship stripping, coercive expatriation, different models of citizenship and how they come into conflict, and how recent events, not least the Boston bombings, bring these questions into clearer focus. We have a great panel to discuss these questions this afternoon, and let me very briefly introduce each one. Sitting at the other end of the stage there is Peter Spiro, who's a professor at Temple University's Beasley School of Law. Next to him is Vladeck, a professor at American University's Washington College of Law. Next we have Leti Volpp, professor at the UC Berkeley School of Law. Next, Muneer Ahmad, who's a professor at the Yale Law School. And Ramzi Kassem, who's a professor at CUNY Law School. You can read more about each of these speakers in the bios that you have in your conference programs, but let me just say a couple of things about the whole group, rather than focus on anyone in particular. First, many of the people on this stage today are frequent visitors to Fordham and have made contributions to the Fordham Law Review. Some have taught at Fordham as well, and it's great to have all of you back here and be able to welcome you back, either if you've been here before or for those of you who are newer here. Second, and this I think is particularly important for the students who are here, because we have many, this panel, like the other two, features law professors with an unusually wide array of experiences, both in the academy and in practice, representing clients directly, but also filing amicus briefs in some of the most important cases over the course of the last decade and before that. Some of these panels have been in and out of government service and teach both in the conventional classroom and in clinics, and I'm sure the breadth and depth that all of you bring to bear on these questions will add tremendously. So with that, Professor Spiro.
Thanks, Joe. It's always great to be back at Fordham. Linda and I were wondering earlier about the fact that the Fordham Law Review is the 5th most cited law review in the country, and I think that the quality of the symposia is a big part of that story. So it's nice to be a part of a great tradition with the law review and its events. So what I'm going to spend a little bit of time talking about today is expatriation in the context of terrorism, that is, termination of citizenship. And I want to focus on an episode from a couple of years ago, May of 2010, when Joe Lieberman introduced a piece of legislation entitled the Terrorist Expatriation Act, which would have terminated the citizenship of individuals engaging in hostilities against the United States, providing material support to foreign terrorist organizations with the intent of relinquishing U.S. citizenship. So what I want to do with this episode is address a puzzle, and that is that this piece of legislation went nowhere. It fell completely flat on the Hill with the administration, and this in a context in which there are a few episodes in which Congress has been cool to counterterrorism measures. So this is a context in which the norm post 9/11 has been that Congress has jumped on all available tools as part of the counter-terror agenda. So that presents a puzzle. It's a puzzle, I think, that's deepened a little bit by the fact that other countries, most notably the United Kingdom, have adopted such legislation and have put it to work. So the UK has expatriated a number of individuals for engaging in terrorist activities. And then the third part of what makes this a puzzle, in my view, is that the legislation itself would have been constitutional. So there wasn't an argument about its constitutionality by way of explaining why it wasn't enacted or even seriously considered. So I want to make three basic points in my few minutes on this. The first is to situate the Terrorist Expatriation Act in the history of expatriation in the United States, which is an interesting history, and it's also by way of explaining why the Lieberman measure was constitutional. Secondly, I want to suggest that the explanation for why the proposal fell flat can be found in its lack of instrumental value. You'll notice that when Ben Wittes is talking about all the tools available in the counterterrorism context, one that was not mentioned was stripping citizen terrorists of their citizenship. So lack of instrumental value, I think, is a key part of the explanation for why this went nowhere. And then finally, I want to explore briefly why some expected expressive value in such a measure, even if it lacked instrumental value, was apparently not enough to generate support for the legislation. So this proposal comes at the end of a fascinating history of expatriation. It used to be quite a common practice. There were tens of thousands of individuals who lost their citizenship through the mid-20th century. In many cases, it was because of naturalization in a foreign state. So under the Expatriation Act of 1907 and the Nationality Act of 1940, if one naturalized in a foreign state, one lost one's U.S. citizenship thereby. So if we were meeting 50 years ago, you wouldn't have Martin Flaherty proudly displaying his two passports because he would have risked the U.S. one in so doing. More relevant to the Terrorist Expatriation Act, service in a foreign armed service was a ground for expatriation. And this resulted in a large number of expatriations in the lead up to World War II. So, in fact, anyone who enlisted in an Axis army, or in fact, any foreign armed service, so before the U.S. entered into the war, even entry into the UK or Canadian armed force resulted in loss of citizenship. And that presents a differential history to today's history, to the extent that the enemy combatants that we were against did not have citizenship by operation of the expatriation acts. The Supreme Court upheld the constitutionality of terminating citizenship in those and other contexts, including women who married foreign men automatically lost their citizenship for several decades at the beginning of the 20th century, so long as the underlying conduct itself was voluntary. So if you voluntarily married a foreign male, a woman is gender discriminatory, so long as the marriage itself was voluntary, you lost your citizenship. The voluntariness requirement posed some interesting questions in the context of foreign armed service, to the extent that arguments were put forward that such service was involuntary. So in the wake of World War II, many Germans, Italians, Japanese who served in those armed services sought, and in some cases recovered, their U.S. citizenship on the argument that their service in a foreign armed service was undertaken under duress. The constitutional picture changed in 1958 with the Supreme Court's decision in Trope versus Dulles, which held that there could be no punitive use of expatriation. That case involved expatriation on the ground of military desertion. So going AWOL was a ground for expatriation that was struck down in 1958. In 1967, in Averim versus Rusk, the court much more severely circumscribed the use of the expatriation power so that in that involving a case in which expatriation was undertaken on the ground of voting in a foreign political election. The court in that case, in an opinion by Justice Black, appeared to deny the government's power to expatriate. Although in the practice, it still was possible to lose your citizenship against your will, or where one manifested an intent, a specific intent to relinquish citizenship, and that requirement was refined in the 1978 case of Vance versus Terreses. And so that's where the law stands in the section of the Immigration and Nationality Act, Section 349, was amended to reflect this specific intent requirement, so that one can only lose one's citizenship under this regime as set forth by the Supreme Court if one wants to lose one's citizenship. And leaving aside the terrorism context, it's now the case that it's pretty much impossible to lose one's citizenship against one's will. You have to renounce your citizenship at a U.S. consulate overseas to effect the termination of citizenship. So the Lieberman measure was a self-conscious update of this expatriation regime to add an expatriating ground for engaging in hostilities against the United States or providing material support to a foreign terrorist organization with the intent of relinquishing citizenship. And it's because, and for that reason, I think it was a constitutional proposal, because it retained the specific intent requirement. You only lose your citizenship if you undertook hostilities against the United States with the intent of relinquishing your citizenship. But it also goes a long way to explaining why the measure wouldn't have been much good as a counterterrorism tool. Because one had to demonstrate this specific intent, and doing that would be difficult in all cases except those in which somebody basically said, I'm undertaking these hostilities against the United States with the intent to relinquish my citizenship. And there's really only one notable case in which the Terrorist Expatriation Act would obviously have applied, and that's the case of Adam Gadon, who was a YouTube, I guess still is a YouTube jihadist, who took his U.S. passport and shredded it on camera in such a way as to pretty clearly indicate a specific intent to relinquish his citizenship. But in all other cases, demonstrating the specific intent would be difficult to undertake. The other reason that it lacks much instrumental value is that is the dwindling differential between citizens and non-citizens in this context. And I think we're hearing a counter-narrative here to David Coles from this morning, from Andrew Kent and from Ben Wittes at lunch, a story of convergence between the treatment of citizens and non-citizens, and I think that applies broadly beyond the counterterrorism context, but in this context as well. There are really only three ways in which citizenship makes a difference for purposes of counterterrorism. There's Guantanamo, there are the military commissions, and there are targeted killings. Guantanamo and the military commissions are really legacy phenomena. No president, Democrat or Republican, is going to send anybody, non-citizens included, to Guantanamo in the future. The military commissions, one can probably say the same about them. And then with respect to targeted killing, whatever it takes to make the kill list is less than what it would take to expatriate an individual. So why look to strip an alleged terrorist of citizenship when you can more easily strip him of his existence? So again, by way of a counterterrorism tool, there's not much that advances the ball by stripping the individual who was already associated with terrorist activities of his citizenship. So that's, I think, a good explanation for why this proposal was pretty much shrugged off. There's still this question about its expressive value. So even if it wouldn't have been valuable by way of advancing a counterterrorism agenda, why not do it anyway? I mean, congressmen are not averse to undertaking political grandstanding. In this context, more than any others, and one might expect that there would be a political payoff to calling for the expatriation of terrorists. Also by way of making clearer the divide between the us and the them. Here, I'm not sure, one thing that makes this a difficult episode to talk about is there actually wasn't that much reaction at all. And so genuinely looking for suggestions, and I think Steve is going to be speaking also to the act next as to why this expected expressive value wouldn't have paid off. But one possibility is that it shows that citizenship itself is no longer a battleground for these kinds of questions, that it has lost its meaning in this context as in other ones, and this is yet another episode which demonstrates that more general trend.
Great, thank you. We're now going to go to Professor Volpp. Yes.
Okay. All right.
Made some last minute changes
Yes.
here.
All right.
Top panel.
Okay. Well, let me start by thanking the faculty and the students at Fordham Law School. It's just wonderful to be here, and especially the students. I appreciate all the work you put into this. On April 15th, 2 bombs were set up during the Boston Marathon. As Amy Davidson, writing in the New Yorker, notes, a 20-year-old man who'd been watching had his body torn into by the force of a bomb. He wasn't alone in this, but he was the only one who, while in the hospital being treated for his wounds, had his apartment searched in a startling show of force, with the phalanx of officers and agents in 15 minutes. According to CBS News, a bystander saw the young man running, badly hurt, and then tackled him, bringing him down because he looked suspicious. The New York Post immediately asserted investigators have a suspect, a Saudi Arabian national. By Tuesday morning, report after report said he was a witness, not a suspect. Social media sites, Reddit and 4chan discussion groups providing a site for people to try to identify the perpetrators popped up. These were collections of photographs with suspects circled and notes scrolled next to the photos explaining the reason why the person circled was allegedly suspicious, in some cases stating brown. An individual picture that had attracted more than 2.5 million hits finally had to be once replicated on the New York Post front page with the headline, "Bagmen, Feds see these 2 pictured at Boston Marathon." They turned out to be a 17-year-old Moroccan-American high school runner, Salim Barhoum, and his running coach. Barhoum told reporters that even after he was cleared, he was terrified to go outside. Speculation then swirled on Twitter and Reddit that one of the men, the white hat wearing one in photos released by the FBI, images released in part to try and tamp down internet rumors, was Sunil Tripathi, the Brown University undergraduate prone to depression who'd been missing from his dorm room since March 16th. Reddit later apologized to Tripathi's family for fueling online witch hunts and dangerous speculation which spiraled into very negative consequences for innocent parties. Juan Cole posted a blog titled "Moroccan Indian Have Lives Ruined by Old New Media." Sunil Tripathi had no life to ruin, as he was already dead, his body found in Indian Point Harbor off Providence, Rhode Island on April 23rd. Why these men were identified by the public as potential terrorists can be understood through the lens of September 11th, which was followed by a nationwide wave of hate crimes against persons and institutions perceived to be Arab or Muslim, distinguished, according to Human Rights Watch, from previous hate crime waves by its ferocity and extent, including several murders. In Boston, the public was not engaging in hate violence after the fact, but in what we can understand as vigilantism, self-appointed doers of justice who in another time resorted to the news. What we also see emanating as a legacy of September 11th is a version of Minority Report, the public functioning as a pre-crime unit, fingering suspects based upon their propensity to commit crime. In this case, propensity indicated by the descriptors brown and Muslim, or looks Muslim. But now we come to the 2 brothers who appear to be responsible, Tamerlan and Jahar Tsarnaev, both Chechen immigrants who were able to gain legal permanent residence as derivative beneficiaries of their father's successful 2002 application for asylum. The initial reaction, it's fair to say, was shock. Chechens? The lack of knowledge in the U.S. public about Chechnya, a war for independence from Russian federal control since the 1991 dissolution of the Soviet Union, is indicated by the fact that the Czech Republic felt compelled to release a statement The Czech Republic and Chechnya are two very different entities. The Czech Republic is a Central European country. Chechnya is a part of the Russian Federation. A press release which seems ludicrous as one sees the Twitter feeds expressing sentiments like, quote, "I can't believe that pair in the Boston bombing was not Tallow-heads. They are Czechoslovakian. Damn, you are Czechoslovakia." This shock was followed by intense media scrutiny of their parents' journey to the United States. Did you know they both studied law before ending up as a car mechanic and cosmetologist? Their parenting and their reverse migration following divorce, as well as following Vladeck Tsarnaeva's arrest in 2012 for shoplifting $1,624 worth of women's clothing from Lord & Taylor. There was intense scrutiny of Tamerlane's U.S. citizen wife, the all-American girl Catherine Russell, with her physician father, who went to Exeter and Yale, and her mother, who was a nurse who lived in the leafy suburbs of Rhode Island. Russell converted to Islam after meeting Tsarnaev and apparently worked long hours as a home health care aide while Tamerlane took care of her 3-year-old daughter, Zahira. As the Daily Mail put it, Russell had hidden her tumble of chestnut hair beneath the hijab. Ann Coulter, who said that U.S. policy of assimilating immigrants into our culture isn't really working. No, they're assimilating us into their culture, proclaimed that Russell, quote, ought to be in prison for wearing a hijab, and then asked of Russell, did she get a Twitter-dectomy too? Remarks which she later excused as a spontaneous joke. Russell raises the anxiety of the convert. The convert in the eyes of Ann Coulter and others is unfathomable. The Daily Mail reports she was brainwashed. While there is as yet no indication that Russell was involved in the Boston bombing, it is worth noting that the convert raises a specter of an unknowable threat, a homegrown threat who is not containable and not identifiable. Unlike the Muslim non-citizen or immigrant in the eyes of the state, witnessed the myriad ineffectual and harmful efforts after 9/11 to use immigration law in the war on terror, which we heard David Cole talking about this morning. There was also extensive media reporting about Tamerlane Tsarnaev's Amazon wish list and the brothers' favorite videos on YouTube. The intense scrutiny of both brothers' use of social media sites included New York Times literary reviewer Michiko Kakutani's analysis of Jahar's Twitter feeds, criticized both for her failure to notice when suspicious feeds are actually song lyrics and for her characterization of Jahar's posts on his V-Kontakte Russian social networking site as harsher, as listing under worldview of Islam, and the link to a website that says, and do good, for Allah loves those who do good. As for those favorite videos, U.S. officials reported that under interrogation, Jahar Tsarnaev said that he and his brother had studied the teachers of Anwar al-Awlaki, who, as we know, was killed, as was his 16-year-old son, Abdulrahim, by American drone strikes in Yemen, killings which sharply raise questions, as we heard this morning from Leti about birthright citizenship. Should we allow the continued enjoyment of birthright citizenship for those whose presence here is accidental, happenstance, as well as about the protections one would normally associate with citizenship? In the words of Nasser al-Awlaki, writing in the New York Times, my grandson was killed by his own government. The government has killed a 16-year-old American boy. Shouldn't at least have to explain why. In previous writing, I described how post-9/11 the imagined community of the American nation, constituted by loyal citizens, relies upon difference from the Muslim terrorists to fuse its identity at a moment of crisis. But the circling of wagons is an uneven process that drawing together takes place through the expulsion of some, and that post-September 11th, those who appeared Middle Eastern Arab or Muslim were subject to a strong racialization process, whereby members of this group were identified as terrorists and were disidentified as citizens. The tenacity of this racialization is evident. We can pick just 3 examples. First, the Saudi student in Michigan who in May cooked his favorite rice and meat dish, kapsa, and walked outside to bring it to a friend's house. When he was stopped by the FBI, he'd been called by a neighbor who spotted him strolling in public with what he reported to the FBI was a, quote, bullet-colored pressure cooker. Second, the response to Monday's news that the Miss American pageant had been won by Mina Davaluri of Syracuse, New York. Davaluri, whose parents migrated from Andhra Pradesh in India, is Hindu and a U.S. citizen by birth. Nevertheless, her election sparked the following messages. 9/11 was 4 days ago and she gets Miss America. Well, they just picked a Muslim for Miss America. That must have made Obama happy. And the Arab wins Miss America. Classic. Congratulations, Al-Qaeda. Our Miss America is one of you. And third, the reaction to other events on Monday, namely the death of 12 people at the Washington Navy Yard, a mass killing that crazily seems like it will not stop the national insanity of gun violence any more than Newtown or Aurora or Virginia Tech or name any other episode of mass shooting will. For a brief moment, speculation flared that Aaron Alexis was Muslim. In fact, Chase Logan, whose byline claims that, quote, he has been pursuing truth in politics since his early early days of the Young Republican National Federation, close quote, posted a column headlined, Aaron Alexis, registered Democrat and Obama supporter, stating that Alexis was allegedly Muslim and possibly gay. In one fell swoop, we see the constellation of issues that threaten Obama, with the Twitter feed saying, if he had a son, he would look like Aaron Alexis, Islam, and sexual non-normativity. That Muslim and perverse are conflated is easily demonstrated by a search of the two terms. As Muneer has pointed out, remember the poster circulating in New York City after 9/11 showing Osama bin Laden getting sodomized by the World Trade Center. You can also think of the linking of the perversity of John Walker Lynn's attachment to Islam to the perversity of his father's being gay, or we would think of the interchange during a rally for then presidential candidate John McCain when a woman took the microphone and said, quote, I can't trust Obama. I've read about him and he's an Arab. And McCain's response, no ma'am, he's a decent family man. But back to Aaron Alexis, since it turns out he is not a Muslim but in fact practiced Buddhism, he is not called a terrorist who receives the label of a shooter. To take these three examples, we could say that whatever a Muslim person does will be potentially a terrorist act. A person who appears Arab, Muslim, or Middle Eastern is presumptively a terrorist, and mass killing is presumptively the act of Muslim terrorists. It thus seems sadly uncontroversial today that those who appear Middle Eastern, Arab, or Muslim are identified as terrorists and disidentified as citizens. But what to make of the Tsarnaev brothers? In thinking about the myriad reactions to Boston, I want to argue that Jahar is perceived as a citizen and Tamerlan as the terrorist. It is quite literally true that Jahar Tsarnaev, currently in custody at a federal medical center, had successfully naturalized as a U.S. citizen in 2012, as people point out on September 11, 2012, and that his brother had not. At the time of his death, Tamerlan Tsarnaev had a naturalization application pending, forestalled, initially reported because of a domestic violence incident involving a former girlfriend, for which he was arrested but never convicted, and is later reported because of an FBI hold. Tamerlan, the terrorist, was considered so monstrous that in death he could not be buried, given the resistance to the idea that he could share the same soil with his victims. As he was already dead, vengeance was left to, quote, exhaust itself on his corpse, close quote. As Chris Haddix writes, the act of burial is a practice of communion with the dead, a reassertion of the connection between the departed and the living. By denying Tamerlan Tsarnaev an eternal home in a Massachusetts ceremony was to deny him posthumous membership in the community, a membership he himself had ruptured. As Daniel Mendelsohn, writing in the New Yorker, pointed out, this was all reminiscent of Creon and Sophocles' Antigone denying Polynices burial as a traitor. Bury this terrorist on U.S. soil and we will unbury him, read a sign outside the Worcester, Massachusetts funeral home that agreed to receive the body. And there he stayed until a woman named Martha Mullen in Virginia took it upon herself to find him a burial spot, following the credo that Jesus says, love your enemies. In contrast to the portrayal of Tamerlan as monster, the younger brother seemed fully assimilated into U.S. life as a wrestler and excellent high school student and was described by friends as sweet, lovely, wonderful, and a total pothead. I have to notice here discussion on Reddit when the videos of him appeared, or of them appeared, with commentators noting that the white hat wearing one took unusually long steps, which is what these Reddit commentators said their friends did when they were stoned and were pretending not to be. As a self-description for motive, we have Jahar's non-Mirandai statement while in custody that they were motivated by the U.S. wars in Iraq and Afghanistan. Some commentators suggest that we need to think seriously about political motivations for attacks on U.S. soil rather than blame Islam. But what I find also interesting is how the response to Jahar suggests the willingness to think about psychology in a way that excuses culpability. He has been described as brainwashed by his older brother, falling under the malicious influence of a father figure in the absence of his parents. One of the victims of the Boston bombing, Michelle Barrera, who lost most of her left knee and a lot of her hearing in the blast, said, quote, I don't know any other religion that kills for their religion and think they're going to heaven. That part's tough to understand. Still, she said, she feels mostly pity for Jahar Tsarnaev. I'm not mad at him. It's more pity. He's a child. You're not born with that much hate. You're indoctrinated into that, she said. There's indeed a striking amount of sympathy directed toward Jahar. There's a free Jahar website with thousands of members who believe it was set up, frankly, a Photoshop, complete with teenage girl crushes, fangirl fantasies, and what Hannah Rosine has called a deep maternal strain, where she writes, in the past week and a half, I've not been to a school pickup, birthday, book party, or dinner where one of my mom friends is nonsense version of I feel sorry for that poor kid. On the DC Urban Mom website, a query asked me, why do I feel sympathetic toward Jahar Tsarnaev, elicited 21 pages of postings in response. There's also a backlash against the notion that Jahar's female supporters are fangirls, with the argument that the male conspiracy theorists, Tsarnaev sympathizers, and anti-government dissenters are not described as engaging in hybristophilia, the sexual attraction of women to criminals, and that dismissing the support as the product of aberrant female sexuality requires us to dismiss the supporters' claim that they believe he is innocent. The perception of sympathy for Jahar also led to the outrage over the Rolling Stone cover, accused of glamorizing him in the mode of Jim Morrison. And in addition to the boycott of Rolling Stone, we now see in response a children's coloring book created to help children understand terrorism, the Rolling Stone picture with an alternative titled, Rock Him and Stone Him. Inside the book, children are instructed, this is what happened to Osama bin Laden, with a graphic of sea creatures refusing to eat bin Laden's fragmented body parts under the water. Whether the sympathy toward Jahar is explained as romantic, sexual, maternal, or political, such sympathy did not seem to appear in the case of Leroy Malvo, the teenage sniper who, when I was living in Washington, D.C. in 2002, terrorized the city along with John Ali Muhammad. And I have to wonder if some of the sympathy for Jahar is related to the articles I've seen titled, Do White People Really Come from the Caucasus? And Are the Tsarnaev Brothers White? The day after the Boston bombings, a Salon columnist asserted, let's hope the Boston Marathon bomber is a white American, arguing that this would limit the resulting crackdown on civil liberties. Then, after the Tsarnaevs were identified, came the response, sorry, looks like they're not white American, and then the rebuttal by Peter Beinart writing in the Daily Beast, but they are white Americans. They hail from the Caucasus. They're literally Caucasian. You can't get whiter than that. But as Beinart also wrote, in public conversation in America today, Islam is a racial term. Being Muslim doesn't just mean being Christian or Jewish, it means not being white. In other words, I wonder if some of the sympathy for Jahar and the antipathy for his brother reflects not only this belief that the older brother brainwashed the younger, but the vacillation between white ethnic and Islamic terrorists that the two brothers straddle, a move between two poles that those who fall into the racial group of appearing Muslim or brown cannot accomplish. Jahar is felt to be a citizen not only as a matter of formal status, he's understood to be a citizen as a matter of identity. For many Americans, he's one of us. Can we say that Jahar Tsarnaev's experienced differently from Tamerlan because Jahar was understood to be white? Regardless of how we answer this question, it is clear that discussions about how citizenship should or should not correlate with particular rights, liberties, responsibilities, effective relationships, belonging, ties of loyalty, must begin from the present premise that citizenship is not an abstract status. The identity of the citizen will shape how his or her citizenship is conceived. For many Americans, their citizenship is formal status, and their citizenship as a matter of identity are completely coterminous. At this point in U.S. history, as Bahar Azmi also told us this morning, for Muslim Americans, the relationship between identity and status is a negative one.
Professor Ahmad.
Well, I want to join my panelists in thanking the organizers, the faculty, and the students for Larby. It's really a pleasure to be here. I'm either allegedly Muslim and possibly gay, or possibly Muslim and allegedly gay. I'd say at the outset. So my working title for my paper is The Citizenship of Others, which is a play on the title of a book by my colleague Sheila Ben-Habib called The Rights of Others. And it's not about the gaining or loss of citizenship in a traditional sense, the topic of this panel, but about the effective substitution of one's claimed citizenship by described ethnically determined citizenship on the grounds of national security. Specifically, I'm looking at the ways in which two countries, India and Israel, distinguish among the citizens of other countries on the basis of national origin and ancestry in the context of visa policies. In both contexts, national security concerns construct a suspect classification based on ancestry that violates liberal notions of equal citizenship. This is to say that the policies of each treat the citizens of other countries differently depending upon their ancestry. Thus, U.S. citizens of Pakistani origin who apply for a visa receive differential treatment by the Indian government, and U.S. citizens of Arab, Palestinian, or Muslim descent receive differential treatment by the Israeli government. By looking at the relatively mundane realm of visa policy, I hope to gain a better understanding of the relationships among national security considerations and competing notions of citizenship, not in the national context, which is where we typically understand citizenship to operate, but in the international one. So my argument proceeds in three parts. First, the policies of India and Israel with respect to U.S. and other citizens violate liberal notions of citizenship, which provide equality to all citizens without regard to descriptive or other differentiating characteristics. If citizenship as rights, to borrow from Linda Bosniak, is understood to be uniform, unalloyed, and indivisible, then these policies violate those norms. Second, a closer inspection of the Indian and Israeli policies reveals what we might term indigenous conceptions of citizenship. It reminds us that while the citizen in theory may be an abstract universal figure, the citizen in practice is a creature of historical and cultural particularity. The reliance upon national origin and ancestry discrimination by India and Israel exposes the multiplicity of citizenship theory and practice across self-conceived liberal democracies. The notion that citizenship values are culturally bounded and that citizenship performs different forms of work in different societies. This should not be surprising, as citizenship is a central technology to the national project, and national projects vary hugely by virtue of history, geography, culture, and ideology, among other factors. To put it another way, while the principle of equal citizenship remains elusive in every society, the nature of the deviation from the principle is likely to vary according to national project. Third, the contradiction among citizenship norms across countries may create obligations for states in the international realm. In addition to all its other meanings, then, citizenship may be understood as a normative project of statecraft. In concrete terms, this means that the U.S., to take this as an example, may bear certain responsibilities in how it conducts its relationships with other countries based on those countries' violations of U.S. citizenship norms. So let me begin with a brief description of the Indian and Israeli policies and the current controversies around them. In the interest of time, I'm going to focus on the Indian example, although I want to make a brief mention of the Israeli example as well, because I think it amplifies some of the arguments I'm making. Now, the liberal conception of citizenship promises equal treatment of all citizens without regard to other characteristics, including national origin and ancestry. But citizenship in its conventional form operates nationally, and the rights of citizens of one country, whether to protection against state intrusion or to healthcare or other forms of social welfare, do not extend extranationally. Presumably that's what human rights are for. The same is true with respect to national notions of anti-discrimination, which according to the liberal model should converge with citizenship itself. Thus, the citizen's right of freedom from state discrimination applies to her state alone. In the realm of visa policy, states historically have enjoyed unfettered authority, as questions of admission have been understood as integral to sovereignty. While recent developments in international human rights law, such as the principle of no refoulement, may begin to apply pressure on these classical understandings, as an empirical matter, discrimination in the issuance of visas remains a state's prerogative. Countries, including the United States, frequently discriminate on the basis of nationality, age, and marital status, not to mention ideology. In the American context, such decisions are immune from judicial review under the doctrine of consular unreviewability. Now, the two examples I discuss here involve not the discrimination on the basis of nationality, but differential treatment of U.S. citizens on the basis of national origin and ancestry, and a corresponding violation of American rights of equal citizenship. Let me start with the Indian example. The story of the Indian policy at issue here begins with the Mumbai terrorist attacks in 2008. Following the attacks, it was discovered that an American, David Headley, had made numerous trips to India on a multiple entry visa in order to scout targets for the attacks. Born Dawood Gilani in Washington, D.C., to a Pakistani father and a white American mother, Headley has admitted to playing a central role in the planning of the attacks, and having changed his first name from Dawood, which is Arabic for David, to David, and adopting his mother's surname, Headley, in order to deflect suspicion upon Indian authorities, because along with his physical appearance and American accent in English, it would allow him to pass as a white American rather than as a Pakistani. Within weeks of the Mumbai attacks, the Indian government announced its new visa policies, commonly referred to as the Headley Rules. Among these policies is a requirement for the Home Ministry, rather than local consulates, to conduct review of these applications for individuals of Pakistani ancestry, including U.S., Canadian, British, and Australian citizens. And with that Home Ministry review, comes significant delays. Whereas a U.S. citizen can typically get a tourist visa to India in 3 to 5 days by going to the consulate here in New York, a citizen of Pakistani descent, U.S. citizen of Pakistani descent, can expect to wait 3 to 6 months, if not longer, and if granted a visa, to be subject to travel restrictions within the country, as well as registration requirements. Martin and I brought my passport with me. The visa that's issued is single entry rather than multiple entry, and it's stamped US-PAC, and that's not a US passport. Now, the Indian definition of Pakistani origin applies to 3 generations: those who were themselves born in Pakistan, those whose parents were, or those whose grandparents were. The application of such a grandfather rule, a grandparent rule, transforms Pakistani nationality into an ethnic attribution, which descends automatically, even to an individual who is one-fourth Pakistani origin, or for that matter, someone whose Pakistani origin precedes the existence of Pakistan itself. After all, people whose grandparents were born in what is now Pakistan, for the most part, were born not even in India, but in a British colony. Now, by this account, Pakistan is rendered an immutable characteristic and a permanent threat, requiring constant Indian vigilance. Moreover, the ascription of Pakistani ethnicity on the basis of bloodline envisions a fundamentally ethnic vision of Pakistani citizenship. The American, in this context, is rendered Pakistani once and forevermore. Although the visa policies enact delays rather than an outright travel ban, the restrictions may effectively deter travel by individuals of Pakistani descent. It's well known in the Pakistani American community that this is the policy of the Indian government, thereby deterring many people from applying in the first place. The U.S. State Department has issued its policy on this on Facebook of all places, and that is aware that the Indian government imposes different requirements on U.S. citizens of Pakistani ancestry, and has expressed concern about this to the Indian government. But the statement adds, quote, "It is the sovereign prerogative of any country, including India and the United States, to issue or deny entry visas to set the terms under which those decisions will be made," unquote. And so the State Department's position reflects accurately the problem posed by the Indian policy. Offense to the principle of equal citizenship within the United States and the sovereign prerogative to regulate entry, a prerogative that the U.S. not only recognizes on the part of India, but is eager to preserve for itself. Now, the long history of enmity and suspicion between India and Pakistan, dating nearly to the country's births, has rendered both countries vigilant to infiltration by the other. The fear of infiltration has been heightened by the commonality of racial phenotype, language, and religious and cultural practices among citizens of both countries, the natural consequence of partition. But the Headley case introduced the specter of a different kind of enemy to the Indian state, one who could pass, not as Indian, a challenge with which the Indian security apparatus has decades of experience, but as American. In this way, the Headley rules reflect a post-9/11 anxiety shared by the West. Fear of the non-terrorist looking terrorist, a category that is itself determined by a decade or more of racial, religious, and national associations of terrorism. The Headley case is an example of the adaptive enemy, adjusting its tactics in response to anti-terrorism measures that rely on traditional forms of profiling. By this account, the Headley rules are the Indian state's counter-adaptation, deploying national origin and ancestry where racial phenotype, religious identification, language, and nationality, as distinct from national origin, proved insufficient markers of terrorist threat. The Headley rules can therefore be understood as a post-9/11 phenomenon. However, the rules resonate with Indian notions of citizenship that predate 9/11 and the Mumbai attacks, and which trace back to the establishment of the state in 1947. Nearly contemporaneous with the Headley rules, which constrict the availability of entry to India, India has adopted a policy for what it terms overseas citizens of India, or OCIs, which expands access to citizenship, certainly expands access to the country, by waiving visa and other restrictions with respect to the Indian diaspora. While its name purports to afford these benefits to, quote, citizens of India, the OCI status is in fact reserved for foreign nationals of Indian descent, which is to say non-citizens of India, thus troubling the traditional citizen-non-citizen dichotomy and introducing a multiplicity of state citizenship practices. We might think of this as a qualified form of a right of return. Now, the definition of OCI mirrors almost exactly India's functional definition of Pakistani origin. Indianness is constructed to extend back up to 3 generations, again applying a grandfather rule, the same as with the construction of the Pakistani. This suggests that foreign nationals of Pakistani descent are viewed by the Indian state as overseas citizens of Pakistan, in the same way that foreign nationals of India are viewed as overseas citizens of India. The Indian and the Pakistani are thus constructed as each other's inverse, as essential, immutable, and oppositional categories, recalling Etienne Bolivar's observation that modern conceptions of citizenship rely upon, quote, otherness as an indispensable element of its own identity, its virtuality, its power. Now, the legal inscription of Indian citizenship is in fact inextricable from partition. The first definitions of Indian citizenship appear in the Constitution of 1950 and give substantial attention to the granting of citizenship to migrants from Pakistan. In fact, the citizenship chapter of the Constitution establishes the template for determining India's contemporary understandings of the Pakistani and the OCI construction of the Indian, for it too determines citizenship based on 3 generations. Among other categories, the Constitution confers citizenship to individuals who either themselves, their parents, or their grandparents were born in pre-partition India, and who either migrated and became ordinarily resident in the territory of post-partition India before the date of independence, or migrated after partition and registered as citizens. Thus, the Constitution's foundational definitions of citizenship, originating in the political imperatives of partition, prefigure the state's contemporary definitions of Indian and Pakistani citizenship. Now, I'm just about out of time, so I'm going to just touch on a couple of things briefly. A series of amendments to India's citizenship law since the 1980s has progressively privileged jus sanguinis over jus soli citizenship, thereby moving India increasingly toward an ethnic model of citizenship. The deterritorialized citizenship of the OCI reinforces this trend. And so, differentiation from the Pakistani is part of the deep structure of citizenship in India. Rooted in the foundational trauma of partition and fueled by religious and cultural nationalism within India and Pakistan, the imperative to differentiation has assumed new relevance within India following the September 11th and the Mumbai attacks. In this context, then, national origin and ancestry are constitutive of Indian citizenship, Indian understandings of citizenship, rather than antithetical to it. Okay, so just let me say a couple of very brief words on the Israeli example, and then I'll wrap up. In March of 2013, companion bills were introduced in the House and the Senate, titled the United States-Israel Strategic Partnership Act of 2013. There are 338 co-sponsors in the House, 51 in the Senate. The bill declares Israel, quote, a major strategic partner. And among other things, it would allow Israel, in fact, require Israel's inclusion in the visa waiver program, a program that 37 countries currently participate in. 40% of all overseas visitors from the United States enter under the program. And what the program does is to waive the ordinary consular visa requirement for visitors from a country that's a part of the program. It has clear practical and economic benefits because it facilitates tourism and commerce. It also is important on symbolic grounds. It's viewed as an expression of amity and trust between the United States and member countries. Now, in order to enter the program, the statute requires that countries satisfy several statutory requirements, including demonstrating a low rate of visa denials in recent years, adoption of certain passport technologies, information sharing agreements, and a requirement that the country offer, quote, reciprocal privileges, unquote, to U.S. citizens. Now, the term reciprocal privileges is unclear in the statute, not clearly defined, but the consensus view is that Israel's current policy of treating U.S. citizens of Arab, Palestinian, or Muslim origin differently with respect to entry and exit does not meet the reciprocal privileges requirement. As a result, the Senate version of the bill modifies this requirement so as to require Israel only to make, quote, every reasonable effort without jeopardizing the security of the state of Israel to ensure that reciprocal travel privileges are extended to all United States citizens, unquote. I won't go into this in more detail. I just want to note very briefly 4 characteristics which resonate with the Indian example. First is an ethnic definition of Israeli, or certainly a trend toward an ethnic definition of Israeli, and a companion ethnic definition of Palestinian that transcends actual citizenship as legal status, and is based on bloodlines subject to grandfather rules. Second is a kind of foisting of citizenship upon others, a requirement that U.S. citizens of Palestinian descent, for example, travel on Palestinian passports or not travel at all, even if they don't already have a Palestinian passport. So a kind of ascription of Palestinian citizenship to those who don't otherwise claim it themselves. Third is a vulnerability of citizenship claims to national security concerns, which is reflected in the Senate language, amending the reciprocal treatment requirement for participation in the visa waiver program. And last is the centrality of citizenship to the national project and the assimilation of putative citizens in an international context into a domestic understanding of the citizen and the citizen's other. What I hope to do in the remaining part of the paper is to talk about what this conflict among citizenship values means for the ways in which countries engage with one another, and to think about citizenship as a form of statecraft for countries to engage in that may bear a similarity to the way in which human rights norms can be propagated, but may bear important differences as well.
Professor Kassem.
I'm going to take a slightly different approach. One challenge I've attempted to take up these past few years is to ground my scholarship in our more social justice-oriented clinical practice at Yale Law School. So my hope is that this kind of scholarship can then feed back into social justice, whether it be clinical or otherwise. So this manuscript that I'll discuss with you here today stems from a few cases that we're handling in CLEAR. Let me tell you a bit more about CLEAR. Let me tell you a bit more about CLEAR. It's a project that we started at CUNY Law School. It's a collaboration between my clinic, the Immigrant Non-Citizen Rights Clinic, and the Defenders Clinic, the Criminal Defense Clinic at CUNY. We offer a range of legal services free of charge. So we represent people who are approached for questioning by the FBI or the NYPD, for example, in connection with counterterrorism investigations. Coupled with that is an ongoing and widespread rights awareness campaign. We facilitate lawyer rights workshops in different communities in New York City. And we also support communities that are targeted by so-called counterterrorism policies and practices here in New York City in their efforts to organize and shape these policies that affect them. So out of those relationships, be it the lawyer rights workshops or our support for ongoing organizing and mobilization efforts, we got a lot of cases that are referred to us. And so the cases that I want to tell you about today that led me down this path involve the confiscation of passports of Yemeni Americans specifically. So let me tell you about two of our clients. One of our clients, let's call him Jawar, is a Yemeni national by birth. He naturalized as a U.S. citizen here in New York City 20 years ago. Earlier this year, he traveled back to Yemen to spend 6 months there with his family. And over the summer, he accompanied his elderly mother to the U.S. Embassy compound in Sanaa. And that was in relation with her application for a visa to come visit him here in the United States. So at the U.S. Embassy, officials abruptly confiscated Jawar's U.S. passport and ejected him and his mother from the press. Another CLEAR client, let's call him Mansour, is a 22-year-old naturalized U.S. Yemeni American citizen who had temporarily relocated to Yemen in order to get married. When he and his spouse had their first newborn in Yemen, naturally they went to the U.S. Embassy in Sanaa to register the birth abroad. At their arrival, embassy officials detained them, all three of them, and began interrogating him, yelling at him, and demanding that he admit that he had concealed his true name. They then threatened to keep him and his wife and their newborn detained in their custody until he agreed to sign whatever agreement they were, whatever self-incriminating statement they were putting in front of him. Ultimately, with his family in tears and terrified, officers finally again confiscated his U.S. passport and expelled him and his family from the compound. So our partners, CLEAR's partners in the Yemeni American community here in New York City, predominantly in Brooklyn and the Bronx, have described a widespread pattern of passport revocation targeting Yemeni Americans from all over the country, not only in New York City, but also in California, upstate New York, other concentrations of Yemeni Americans. At that specific site, the U.S. Embassy in Sanaa. And we've done additional research, beyond reaching out to partner organizers and community-based organizations, and we found reports in the Yemeni press, the Arabic language press, and in the few English language outlets that exist in Yemen, going back to April, reporting, as far as we could count, more than 20 such known cases of Yemeni Americans having their passports confiscated in similar fashion. At that embassy. That's in addition to the anecdotal evidence that we received through our partner networks. So how do we account for this phenomenon? The first question naturally is, why Yemen? So on one level, it could be an expression of our collective 9/11 warped fear of certain Muslim majority countries and regions. Personally, having grown up in the Arab world, the stereotypes that I associate with Yemen are different. They involve They involve sort of an awareness of Yemen as a pluri-millennial civilization that gave the world its first skyscrapers, more comically, that used to cot. Those are the sorts of associations that I bring to it. But certainly in the U.S. government's view, Yemen takes place of choice as a haven for militants such as al-Awlaki, al-Qalam, and as a holding ground for U.S. drones with devastating effects. So in other words, the context colored this way would seem to call for heightened scrutiny in all official U.S. dealings in Yemen, including immigration and consular services. So how is that heightened scrutiny actualized bureaucratically by the agency on the ground? An unclassified cable from the U.S. Embassy in Sana'a dated September 29, 2009, and released by WikiLeaks may suggest an answer. In that cable, you'll find a statement that all immigrant visa cases are considered fraudulent until proven otherwise. It may well be that another directive imposes a similarly sweeping presumption of fraudulence on all requests for consular services made by U.S. citizens of Yemeni origin in Yemen. But even assuming concrete and individualized suspicion of fraud, which is a huge leap, knowing the facts of our cases are clear and being familiar with some of the other stories, but even assuming that such concrete and individualized suspicion of fraud actually existed in some of these cases, we can still proceed to a more critical examination of the legal mechanisms at play here, as far as we can unpack those. So the starting point for that examination is with this statutory provision. So 22 U.S.C. 2705, which gives a U.S. passport the same force and effect as proof of citizenship as certificates of naturalization or citizenship that are issued by the Attorney General or by a court with naturalization jurisdiction. The consequence of that language, the same force and effect, would be that those documents, namely the certificates of naturalization or citizenship issued by the Attorney General or by a court with direct jurisdiction, those documents can only be revoked following a pre-deprivation hearing. And so when this statute gives a U.S. passport the same force and effect, the argument would be that the passport, too, can only be revoked following a pre-deprivation hearing, which certainly our clients did not receive. The Ninth Circuit agrees with this position, requiring a pre-deprivation hearing prior to the confiscation of a passport. But there's this other provision in the INA. And this provision postdates the earlier provision that we just went through, and it authorizes the Secretary of State to strip passports and dispatch them when certain grounds are suspected: illegality, fraud, or error in the issuance of the passport. Now this provision requires written notice at the person's last known address, both of the cancellation of the passport and of the procedures for seeking a prompt post-cancellation hearing. Now, because this provision of the INA postdates 22 U.S.C. 2705 and postdates Magnuson, it arguably supersedes the Ninth Circuit's argument. So, in my view, it leaves an open question whether pre-cancellation or post-cancellation hearings are required in instances of passport confiscation. But either way, there is a remedy, right? 28 U.S.C. 2201 founds declaratory action as a person can go to federal court and challenge passport revocation. The problem is that there is a section of the INA that I just put up there that limits that to any person who is within the United States. So requests for that sort of declaratory relief, challenging a unilateral passport confiscation by the Secretary of State or her designee, is limited to any person who is within the United States. Now, what is the upshot? U.S. citizens, such as our clients at Clear, have been stripped of their passport without a pre-deprivation hearing. They obviously could not receive notice of post-deprivation hearing procedures because that notice is sent to a U.S. address and they are received. They're arguably precluded from challenging passport revocation in federal court because, again, they are overseas. They're not within the United States. So finally, as a practical matter, right, and this may not be so obvious, they cannot return to the United States unless they still retain valid Yemeni papers and can secure a visa through that same consulate, through that same embassy that confiscated their passport and expelled them. So by implementing this specific policy overseas, the US government is enforcing exile. It is also affecting constructive denaturalization of Yemeni Americans. And we should know that normally this result can only be achieved through denaturalization proceedings in court, through revocation of citizenship following a conviction for naturalization fraud, followed by removal proceedings. But with this policy being implemented in this manner with Yemeni Americans while they're overseas, the U.S. government is reaching the same results, circumventing all the other protections that we normally obtain. So, of course, there are larger, because I'm almost out of time and I want to leave time for discussion, there are, of course, larger implications going to the further exceptionalization of Muslims and their citizenship status in the implementation of U.S. legal policy that I will explore in my paper. And then obviously the situation cries for litigation and advocacy solutions, which we are actively thinking about, are clear, and some of our partner legal organizations are considering as well. And I'm sure the litigators in the room are also thinking about ways to challenge this sort of thing. So with that, I will end and I look forward to questions.
Okay, now Professor Vladeck.
Thank you, Joe. Thanks, Karen, and everyone. Well, you know, thanks to all the Laurie folks for having me. I should apologize actually at the outset for messing up the order of this panel, partly because I had actually planned to say many of the same things that Peter already said and far more eloquently than I could have, and so rather than sound like a broken record, I thought I would instead go last. And part of what I was thinking about both during our panel and throughout the day is, you know, we spent most of today, including this panel, talking about the myriad ways in which the relationship between citizens and non-citizens is or is not legally significant. How citizenship can be taken away, why it matters, how it should matter, whether it even matters. And it seems to me that a good place to wrap things up and maybe provoke some discussion and some conversation was by returning to a question Peter raised, which is why citizenship is so often the fulcrum of these political debates, especially if, as has been suggested at various points earlier today, we've seen some form of convergence when it comes to how our laws differentiate. And the other thing that occurs to me sitting up here is I'm in the amazing position of, for once in my life, being the only inside the Beltway person on the panel, which is a nice change of pace. But so I thought it was sort of interesting to also put in the perspective of, from a political observation point, how this conversation looks different. So let me flash back to the summer. So on July 24th, something amazing almost happened. That's a funny sentence. On July 24th, the House of Representatives came within about 5 or 6 votes of defunding Section 215 of the Patriot Act, which we now, you know, if we knew then what we know now, would have actually succeeded, which we know to be sort of the most controversial element of the NSA surveillance programs, at least of those we've learned about thus far. The vote was 217 to 205. Of the 217 yay votes, it was 83 Democrats, the 217 who sort of defeated the amendment, it was 83 Democrats and 134 Republicans. Of the 205 who would have defunded Section 215, it was 112 Democrats and 93 Republicans. And some of you may say to yourself, you know, Democrats and Republicans could not agree that the sun is going to come up tomorrow right now. And so how do you have this weird, amazing, partisan division on both sides, right? What accounts for it? And what's remarkable about this vote, which was on an amendment offered by Congressman Amash, is that it really was actually the third different example of a major national security policy conversation in the last 3 years where we've seen this kind of alignment or realignment, where we've seen not a strict party line vote, but rather the flanks of the parties, the liberal, progressive flank of the Democratic Party, the very conservative libertarian flank of the Republican Party, joining hands against the middle, losing usually, but still doing it. And so the question is, sort of, what are these other examples and what do they tell us? So the second example, I'm going backwards now in chronological order, we also talked about this a little bit earlier today, is the Stand with Rand filibuster. What is his name? You know, it was Ron Paul, I don't know what the word is. You can't stand with Ron, you know. On with Ron. And the Stand with Rand filibuster, if you guys remember, was about a very specific question that had been asked of Attorney General Holder. right? The question was, does the United States ever claim the authority to use a drone strike against a U.S. citizen having a cup of coffee? Right? I think it was Senator Cruz who put the question to the Attorney General, and the Attorney General equivocated because that's what Attorneys General do in that context. And indeed, I mean, it was just 3 weeks later that after the Boston Marathon bombings, all of a sudden it was like, maybe, right, sometimes. And the filibuster had the same elements. It had this sort of real concern about treating citizens in a way that would be unaccepted. And then the first example, sort of, and the third in my list, going back chronologically, in December of 2011, what was then a hitherto unheard of coalition between these flanks almost halted passage of the FY 2012 National Defense Authorization Act. The money for the military, a bill that is always passed no matter what, usually on December 31st, but no matter what. And back then, the issue was whether Congress in the NDAA was going to authorize military detention of individuals within the United States. And after securing passage of what's known as the Feinstein Amendment, Section 1021E, which provided that nothing in the NDAA altered existing law for people who were picked up in the United States, the coalition stood down. And the NDAA safely passed. And so all these examples sort of struck me as, sort of how the politics are realigning on these national security questions, right? So with regard to targeted killings, Attorney General Holder sends a letter to Senator Paul that says, no, in fact, we don't claim the authority to use targeted killing attack on a U.S. citizen having coffee at a cafe as long as he's not involved in combat. Right, just combative coffee. And that led to Senator Paul standing down. Right, it certainly appeared to mollify him. He declared victory. He withdrew his opposition to the Brennan nomination, and life went on. And so in both cases, right, the little sort of cave on the citizenship question takes the wind out of the libertarian critics' sails, and the critics, many of whom sort of return to their regular scheduled programming, wait for the next possible time to strike. And I guess what strikes me about these 3 episodes is I think we can characterize them all, perhaps unfairly, but I'm going to do it anyway, as libertarian hijacking. And what I mean by that is instances where libertarians form a short-term coalition with progressive Democrats, usually on national security issues, only to pack up and basically go home once they've extracted concessions that don't actually resolve the real issues. Right? Even worse, in all these cases, these efforts appear to consume most, if not all, of the available oxygen and political capital, obfuscating, if not downright suppressing, the far more problematic elements of the relevant national security policy. So even when progressives sought to continue the debate and or pursue further legislation on the relevant questions, and a good example of this in the detention context, Senator Feinstein also introduced a bill called the Due Process Guarantee Act, which would have categorically forbid military detention of anyone arrested within the United States. There was no more support, right? The punitive satisfaction of the libertarian objections necessarily arrested any of the remaining political inertia. So in the context of detention, the libertarian push to clarify the state of the law with regard to detention of U.S. citizens, right, both did not succeed on its own terms and obscured what Congress was doing in other cases, which was arguably expanding detention authority to be non-citizens picked up overseas. Right? The same in the context of drones. The libertarian push to clarify the circumstances in which the government could conduct targeted killing operations even on U.S. soil, both left open important ambiguities concerning when such force could be used. So what does Holder mean when he says not involved in active combat, sitting there with his coffee? And in any event, took all the attention away from the pervasive use of such force against non-citizens overseas. Right? I mean, we have reports from reputable figures like Senator Lindsey Graham that as many as 4,700 non-citizens have been killed in drone strikes, and 4 or 5 U.S. citizens. And so all the focus is sort of on fact patterns that, if they arise at all, are an incredibly small percentage of the cases. Right? That in the conversation in Washington centers on cases that don't arise or that arise far less frequently than the ones that are really far more important from a law enforcement rights perspective. Right, and the same can be said, at least thus far, on surveillance. Right, so virtually all the attention, all the media coverage, at least in the U.S. or inside the Beltway, has been on the interception of communications and or obtaining of telephony metadata of citizens, right, of our stuff, even though in many ways some of the more significant revelations and arguably some of the more legally problematic activities have involved what we've been doing overseas and what we've been doing vis-a-vis non-citizens, right? And that's not part of the conversation in America at all. If you read Der Spiegel every day, you would see it. If you read the New York Times and Washington Post, you won't see it at all. Now, don't get me wrong, there are obvious political reasons why in all of these circumstances, focusing on the government's authority on the home front has been more politically expedient and has commanded a greater and more bipartisan coalition of critics. I mean, that's not surprising, it's not unusual, and it shouldn't be, I think it's expected. But lest we miss the point, I think these examples highlight not just that libertarian hijacking tends not to accomplish much, other than grabbing headlines and denying to the government authority it doesn't really claim, but actually it might be counterproductive from virtually every other perspective, whether it's a matter of civil liberties, human rights, democratic accountability, or even governmental efficiency. Right? So what do I mean? Well, so the civil liberties and human rights objections are obvious. Right? On the assumption that Congress only has a finite attention span, spending all this energy trying to circumscribe authorities that have rarely, if ever, been used leaves little to no room for the cases that actually matter. Right? Not coincidentally, these cases tend to involve folks least likely to have a loud voice on Capitol Hill, non-citizens outside the United States. And although it's bad enough that Congress merely ignored those cases, right, in the detention context at least, the attention to the home front hid from view the extent to which Congress has embraced more authority in those classes of cases, has actually expanded the government's power while we've all been looking over here. The same may be said, the same may yet happen, right, when it comes to drones and surveillance. The accountability concerns are perhaps a little bit less obvious, but I think they're no less poignant. Rather than take advantage of a rare moment of bipartisan agreement to demand greater accountability from the Obama administration when it comes to drone strikes in general, right? For example, how many have there been? What countries have they taken place in? Anything like that. Congress only leveraged the government into turning over a small handful of memos specifically related to the count on one hand number of cases involving U.S. citizens, and even then only to the members of the respective intelligence committees and not their staffs or their other colleagues. Right? And it remains to be seen whether Congress will accomplish any more in the surveillance context. If you've been following the conversation, right, so far the focus has not been on scaling back authority under 215, it's been on making the court stronger, because that will solve all of our problems. But the cost to the government is also relevant, right? As the Rand Paul filibuster demonstrated, government officials end up having to expend a remarkable amount of energy to either defend or reject their authority to undertake conduct they would seldom or never attempt, and then to endure and be forced to respond to criticisms because someone like Attorney General Holder had the temerity to suggest that there might be exceptional circumstances where such uses of force might be permissible. Right? So ultimately, there are important questions to have about current and future U.S. policy when it comes to targeted killings, when it comes to detention, when it comes to surveillance. But if these examples are any indication, the most visible libertarians in Congress don't appear to be interested in having them. And that's certainly their prerogative. But in that case, I think we might all be better off if they let those conversations take place, rather than hijacking them and turning them into debates in which there's virtually no one on the other side. Not because there's nothing to their points, but because there's so much more in what's not being said. So construed, right, citizenship, the whole focus of our discussion today, becomes a cover. Right? It becomes a safe middle ground for political agreement. We can all agree citizens are the easy or the hard cases, right? And a way to avoid far harder and far more vexing questions of U.S. national security law and policy. And expatriation, or denaturalization, becomes a way of removing from that cover those who we deem unworthy, not because we're sure non-citizens are beyond the protections of our statutory and constitutional rules, but because we're not. Thank you very much.
So I know that people probably have questions, but first, maybe other panelists want to respond to things that others have said.
Can I actually ask about the convergence thing? So I think in the earlier panel, people were saying, oh, here we've written about this convergence. But I guess listening to the first panel today and thinking about what David Cole was saying, what Von Osby was saying, I was thinking both of these things have to be said. In other words, if there's a convergence of how people think of the value of citizenship with what we think of as what non-citizens are entitled to. It's because there's a very specific diminution of the citizenship for a particular group of people, which is Muslim Americans, right? And then what's going on here is that there's a sense of, who's like us, right? Who's not like us. And if there's a diminution of the rights of people who are not like us, well, then that's okay. If it's me with my coffee in a coffee shop, yeah, that is a problem. But anyways, I was
So it's a different way of drawing the line, not on legal status, but on other dimensions.
I'm not remembering if it might have been Derek Bell. I'm trying to remember who said this. Someone wrote, and if I'm screwing up, I apologize, that there's a profound irony in the Supreme Court's jurisprudence with regard to citizenship in the 19th century, right? That in Dred Scott, everything turned on the fact that slaves weren't citizens. And then the second that citizenship was conferred by virtue of the citizenship clause of Section 1 of the 14th Amendment, the slaughterhouse cases comes along and denuded citizenship of any meaning and any value, right? And so I think part of the problem is that the word convergence, right, is context specific. Right? That there are some contexts in which there has been some convergence, there has been some sort of move to break down the barrier between citizens and non-citizens when it comes to rights, right? But that there are other contexts where it's going the other direction. And so I think, it's hard to generalize, I guess is what I'm trying to say. I think it really depends on the specific sub-issue and even the specific right that we're talking about.
But I think the idea behind convergence as a trend is that increased protections are being conferred on to non-citizens on the one hand, whereas citizens are going, rights of citizens are going the other direction. They're going to meet somewhere in the middle. I think that's misleading if the evidence that you have for the increased protections afforded to non-citizens are such things as habeas rights accorded under the yes, because pick your Guantanamo lawyer in the room. They will tell you that who again protections have effectively been vetted by the Court of Appeals since 2008. So I think really the better way to describe the progression is not so much as convergence. I would describe them as really a race to the bottom. Race to the bottom.
Do we have questions? Yes.
I may be bringing up a whole other topic, most likely. In my life, usually the word citizen is, when somebody's mad, is got the thing ahead of it of like, I'm a tax-paying citizen. And I would love to have anybody who cares to address, because when you talk about how this legal treatment of foreigners, etc. Also look at how the poor are treated. Stop and frisk, people being in jail, even though it's against the law, it's being institutionalized. How the poor are treated. And I wonder if there's anybody here who feels that there's some aspect of citizenship in America and of what you're talking about in terms of international, that the international citizens here that have most rights are those who have the most money. And there are American citizens whose rights are quite challenged because they are foreign nationals and they are poor.
I don't know that you're going to get any disagreement from anyone who said. I think it's an unfortunate staple of the Supreme Court's equal protection jurisprudence that the court has, with the exception of Justice Marshall, right, that the court has been incredibly reluctant historically to treat wealth or poverty as a suspect classification, right, and that as a result, the court has, sort of felt itself bound to reach all these results where some constitutional rights are only as good as your ability to pay for them. And I think that's a problem. I think that's a problem that transcends citizenship because, as your question suggests, it's a problem that is equally faced by citizens and non-citizens alike. I think the difference is the statutory side of it, right? I think that for reasons that somewhat dovetail with some of the things that I was trying to say in my remarks, that Congress is more likely to care about the plight of the poor citizens. That there's a constituency, at least to some degree, for that, for that movement. But that constitutionally, I think there are things.
This takes us outside of the national security context, which I'm happy to talk about. I guess another place it might be productive to look at, to think about your question, is the way in which immigration reform has been moving, the way in which immigration reform has been constructed. So The Senate bill, which may not go anywhere now, but certainly represents kind of the closest to some kind of mainstream consensus thinking about what immigration reform might look like. Conditions the ability to adjust from registered provisional immigrant status to a green card upon a demonstration of a performance of a whole range of activities. One of the central ones of which is work. And there's a very strong parallel, I think, between the way in which that kind of progression on this pathway to citizenship is conditioned upon work on one hand, and the way in which receipt of welfare benefits has been conditioned on work since the mid-90s, or even that in states like Wisconsin, but nationally since 1996, 1997. And I think that that's a way of thinking about how we understand how we come to make certain demands about economic productivity in exchange for citizenship. I mean, that's what comprehensive immigration reform gives us. It gives us an opportunity to reflect upon what's the price of admission in a way that doctrinally is not available for birthright citizens. But when we're legalizing millions of people, we're allowed to ask that question. And the parallel, I think, between that kind of conditionality of work and other kinds of economic citizenship with the way in which we've now for 15 years conditioned the receipt of social welfare, I think is a helpful one.
You could also just, not to go too far down this road, I mean, there's terms people come up like fiscal citizenship, there's people...
Corporate citizenship.
Corporate citizenship, neoliberal citizenship. I mean, there are people who've been writing about ways in which the ideal citizen is this self-regulating, productive worker, right, who's earning, and then this has a lot to do in this context with how we're set up on the model of contract as opposed to charities in one particular article as well. So, you know, there's certain people who fall out of what we think of as a citizen who's capable of taking care of oneself. For example, with the people who didn't drive off in their SUVs after, you know, with Hurricane Katrina, but instead were left, who then became called refugees, right? So, as opposed to the appropriate citizen who's handling their own needs.
Okay, so one might add the label. So the overseas citizen India status originally, when it was made available, was only available to citizens of the U.S., Canada, certain European countries, and Australia and New Zealand, which led a South African citizen of Indian descent to label it $1 and £1 citizenship, which I thought was useful. The ways in which we might describe it.
Other questions? Yeah, Marty.
So regarding this convergence versus dichotomy discussion, which is very interesting, I mean, one way I've been thinking about it in light of today's discussion is, you know, one can argue for a general convergence with regard to citizenship, you know, which is tied to the erosion of, you know, sovereignty in various ways since World War II, in this case, the Peter's work, with a big exception of national security, particularly post 9/11, which gives rise to the kind of old joke, you know, except for that, Mrs. Lincoln, how did you like the play? Right, you know, which is if citizenship matters in the national security context in a way that allows virtually, you know, a black hole with no rights concerning non-citizens, then that is a huge exception for convergence. It doesn't necessarily swallow the idea, but the exception is so large that you can't just, you know, talk about convergence without talking about that. One just follow-up question for Steve. Is another culprit here centered at O'Connor? Because, you know, contrary to what Ben Witt has said, you know, my recollection of, say, detention and military tribunals is Rasul is the first case, right? It's a statutory case, but Rasul is the first case. It's not about citizenship. Then you've got Hamdi, and it is a happenstance that Hamdi is, you know, a citizen within the United States. But again, contrary to the text, etc., of the Due Process Clause, O'Connor starts talking citizen, 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 citizen. And that, at least jurisprudentially, sets us down the road of the process that you described, which is citizenship sucks up all the oxygen out of the room in a very unhelpful way.
Which is ironic, especially in light of Hamdi, right? Because, I mean, Marty, you're right, of course, that citizenship has mattered a lot in post 9/11 policy debates. But the irony is that the Supreme Court has tried very hard to knit a value when it comes to legal issues, right? I mean, so Hamdi itself is Exhibit A. You know, the heart of Hamdi is a ultimately unnecessary holding. That the government had the authority to hold Hamdi even though he was a U.S. citizen, notwithstanding the Non-Detention Act, given that they say there was not adequate process, given that 6 justices signed that opinion, the authority holding was actually dicta, or at least it was unnecessary to the result, whether or not it was dicta. So I think, I mean, in a way, O'Connor actually, I think, encapsulates the very tension that we're getting at, which is how can citizenship both matter and not be dispositive? Right? How can citizenship be so important, and yet you're saying, oh, even though he's a citizen, we can still detain him, you know, military detention without trial. And I think the answer is political. I think the answer is the courts want to sort of carve out the government's legal authority and define it not through the citizenship, but at the same time suggest to the government the better part of wisdom would be to apply those authorities in a way to differentiate based upon citizenship. And that message has largely been received, as Benedict rightly suggested at lunch.
Other questions? Yes.
Question for Ramzi Kassem. Thought that the case you're investigating was shocking, and I was wondering if you've been able to find in your investigations whether the Sanaa case is unique or part of a pattern.
Sorry, can you repeat the question?
Oh, sorry. Did you
Wait for the mic. Wait for the mic.
Sorry. I was just wondering if you found in your investigations whether the case in Sanaa was unique or part of a broader pattern.
Yeah, it seems to be part of a broader pattern. I think we've seen 3 such cases.
In other embassies?
So all of the cases that we've seen or that we're aware of or that we've read about involve the U.S. Embassy in Sanaa. See no reason why this sort of policy would be limited to the Yemeni Americans. I can see it being expanded to Pakistani Americans, American citizens coming from countries that are equally a cause of concern to the U.S. government's view. We're not aware of that. We haven't seen those patterns yet beyond the Yemeni American community, but it does seem to be a widespread pattern within that specific community for now.
I think we probably have time for one last question. Yeah, Tom.
Yes, I'm going to sort of take Martin's framing and say that, let's say there's been some convergence about citizenship, but national security is sort of an exceptional area. I mean, Peter, your comments were sort of interesting because even though there's been a lot of play there, you suggest that taking away citizenship has now been effectively off the table, right? Which is very interesting. And Muneer, your comments about India, Israel, I mean, are those restrictions, are they, I guess it's very difficult to say if it's about national security or sort of racial, cultural factors, right? I mean, is it more of a functional national security type investigation? Do other countries have similar things? So would you sort of count them? Because it seems to me in the bad old world, sort of racial, cultural things of the sort that Leti talked about were the primary reasons for different kinds of quotas and restrictions on citizenship. Is it still a feature of that, or is it really more about a security reason for those kinds of measures? So I'm just wondering.
So I'm not sure I agree with Marty's premise that national security is an exception. And maybe it's a question of charting a trajectory here, and that in the immediate wake of 9/11, there seemed to be a pretty glaring differential between the treatment of citizens and non-citizens. But partly as a result of the work of people like David Cole and the CCR and other constitutional actors, and I would put those people and groups in that category, there's been a sort of successful pushback so that the differential is now diminishing. And so, as I said, that nobody's going to put anybody else into Guantanamo. I mean, it's a legacy problem. Same thing with military commissions. So I'm not sure that it's inconsistent with the overall story.
Although my quick comeback would be, what happens if we have another attack? I think it all comes back overnight.
I would just say I think that part of what's happening is a convergence of pre-9/11 set of phenomena, which is to say, cultural, racial, indigenous to the regions and these particular paradigms, Israel, Palestine, India, and Pakistan. But part of what I worked through with the paper is to what extent does that just have different resonance post 9/11 or post Mumbai in the Indian context? To what extent is either a set of developments post 9/11 with respect to citizenship that's giving greater authorization to what's going on in this context? So I think that one of the things that to me is really interesting in terms of where we are in our understanding of what has happened in citizenship theory post 9/11 is I think we still don't have sufficient precision in the terms that we use as to proxies. What is a proxy for what, right? So, Leti talked in her paper, and I've written before about racialization of our Muslim and South Asian communities. Is it race? And if it's race, what is race the proxy for? Is it about being Muslim American? Is it about being Arab? And I think that there's a way, and so I raise that because in this context what's going on in both Israel and in India is a reliance on ancestry. And I guess one of the things I'm interested in trying to understand a little bit better is the extent to which an ambiguity about what the relevant proxy is and what the salience of the proxy is may authorize a broader use of a whole range of other proxies. And that's part of what I think is going on in the Israeli and Indian context. It's not fair or accurate, I don't think, to describe the Indian context as being purely about India-Pakistan relationships. I think that's significantly part of it. I think there's a lot of the way in which the thinking about Indian citizenship and Pakistani citizenship has, as I'm trying to show, deep roots in Indian modern history. But I think it's also not coincidental that it's the Mumbai attacks that triggers this new policy. And I don't think that's pure opportunism on the part of the Indian government. I think they actually thought that there was something strategically adaptive about what they were doing that was important. And that strategic adaptation is itself the result of certain deployments of proxies, which led to a heavy figure emerging in the first place, right? Because other proxies were deemed to be, I assume, working well enough that you wanted somebody who could pass in a way that Headley could, in a way that others might not.
But then, I actually think the proxy point also answers the question Peter asked at the end of his talk, which is why the Terrorist Expatriation Act, which I think, could easily have been amended to be constitutional. There are things that I think were constitutional, right? Why it never went anywhere, especially in that Congress at that time. And I think part of it is, expatriation is in many ways a proxy for the paradigm problem that Ben raised a bunch, which is the extent to which we still haven't settled to any reasonable degree whether we think of terrorism as a criminal law enforcement problem or as a conventional use of force military problem, right? And expatriation qua punishment historically has been in the latter class of cases, right? Has been, you went and fought for the Italian army during World War II, we're going to expatriate you. Right? And that doesn't, terrorism, transnational terrorism doesn't fit, right? Fighting for Al-Qaeda is not voluntarily, is not manifesting an intent to relinquish your citizenship, it's not showing fealty to another country. And so in many ways, I think part of it is because it doesn't comfortably, it raises the very paradigm fight that we have not been able to solve in 12 years, and I think we may never solve. I think, the U.S. position has been to subsist in this uncomfortable space between the two. I think that's part of why these questions sort of are raised and then sort of die.
I think it's also a convenient position for the U.S. government to find itself in at the end of this 12-year period, because then you end up with an array of tools taken from both paradigms that it can then toggle between the will and sit down this question. I think that's one of the most troubling things about the world we find ourselves in. The fact that the U.S. government has that discretion to toggle.
Maybe, by the way, if you were with the Italian army, you were against the U.S. at the beginning of World War II, but by the end of it, you were fighting with the U.S.
Right, but
it changed sides.
But there's a famous case of a U.S. citizen who was captured while fighting for the Italian army during World War II, and he brought a habeas petition saying, "You can't hold me, I'm an American citizen." And the court said, "I'm very funny, go home." Right? Yeah.
And maybe on this convergence-divergence point, just in terms of a concluding thought, just come up many times today, it may matter where, we may not know the answer, it may depend where we look. As Peter says, if we think about some of the 9/11 judicial opinions, we see pushback there, and arguably convergence as the Hamdi decision is applied in the extraterritorial context of Guantanamo Bay. But as David raises this morning, when we think about the political branches, or at least Congress, there seems to be divergence, not convergence. Conversely, somebody this morning in the immigration context brings up the Deferred Action for Childhood Arrivals program. Certainly a reason to think that there are elements, I think, of a convergence model that are within that policy. So maybe it really remains to be seen. I want to thank all of our panelists today. And while we're doing thank yous before people get up, there is a reception in the atrium right afterward. But first, I really want to make sure that we thank the folks who have put on this really great symposium today. First, the Center on National Security, Karen Greenberg, Susan Quattrone, and their entire staff really did an amazing job. So thanks to you. I want to thank my colleagues Martin Flaherty and Tom Lee for their participation today. Andrew Kent, who worked tirelessly on the conference preparations. Our terrific communications office, which is led by Carrie Johnson. Of course, the Office of Public Programming, which is led by the tireless Helen Herman. She's the reason why we had food today and why things ran as smoothly as they did. And last but not least, the Fordham Law Review, which is led by Matthew Fenn, the editor-in-chief, and Evan Hess, the managing editor. But most of all, we want to thank Alex Wolff, the senior symposia editor, for his great work and his dedication to this. Thank you so much. And now please join us in the